Due to technical problems, Mukhtiar Singh Khalsa's entire talk was not recorded, and the first few minutes of Robert James' talk was also not recorded. Please accept our sincere apologies for any inconvenience. Robert is a foreclosure law expert and author. He was a CPA and practiced law for many years. His full bio is included in the description part of this YouTube page.
It involved foreclosure and some things that were really strange in the courts. I guess I stuck my nose too deep into the materials, going through 1,000 or so cases, foreclosure cases around the United States, and that resulted in this first book. And the bottom line is, and the reason I kept working on this was that I have a lot of respect for our legal system. What I was trained in law school about the objectives, what we're supposed to be doing, how we're supposed to cooperate with the courts as attorneys, a strength in our country that is something to be proud of. In the foreclosure arena, things that happen by what I call the foreclosure machine are really terrible. They deceive the courts. They are very good at deceptive wordsmithing. So they'll play with words that they know will be misunderstood, but they use them anyway with the purpose of having them misunderstood. Our judges, for the most part, docket that they're responsible for. The way to fight back against this foreclosure machine is to help the judges. So I stress that as much as I can, and to put on a case that's in language that the judge can understand. It doesn't have to be legalese. It can be English. It just needs to, but it needs to be something that tracks what the public policy. They're not there to legislate. Judges have their job which requires them to apply the current law to what the current facts are. And because of their workloads, if two parties are in a lawsuit and only one of them ever opens their mouth, that's the only story the judge will ever hear. So it's really important to try to cooperate with the judges. They're humans. They make mistakes sometimes. When I mentioned that I've looked at over 1,000 cases and analyzed foreclosure decisions around the country, I'm looking at appellate decisions for the most part. The lower court decisions don't get published in the legal research tools that are available online and electronically. But this, and I'm not sure, it may have been Craig that said that in some ways the public is helpless. I don't see that. I had too much success in court, and I do think they will give a correct decision. But it's a learning process, and there's nothing simple about it. There's no guarantee. If the first judge gets it wrong, a person may have to go to appellate court to get a better reasoned decision. It's just the way it is. My book, and you can't see it from there, but I just take my word for it. It says, don't assume they win, even if you're behind on the mortgage. That is not cute marketing spiel. It's up there because what I learned over the years was that most people only know one side of the equation. They know if they made a payment or not. They have absolutely no idea what happened with their note. They don't know who it was sold to. They don't know if the people sending letters have any rights to demand payments. The borrower doesn't know if their loan has already been paid off, warranties or settlement, or the investors on Wall Street have sued the big banks for packaging misrepresented loan packages. The borrowers don't know any of this information. So many people, and most borrowers, by the way, I think the Chris talked about this report, this financial crisis inquiry report, 600 some odd pages. That report about the FBI investigating what caused the problems. And the FBI said that they could find no quantifiable evidence at all that borrower fraud or borrower misrepresentation led to the crisis. They couldn't even quantify it. It was all through the industry. And that's in the report that Chris was talking about. There are many good people trying to solve the problem. Some people are working in political arenas. Some people are trying to change legislation. And I get confused easily. I have a lot easier time with things that are more short-term. So that's the reason I focus on litigation. My book is about foreclosure litigation. My papers are about foreclosure litigation. To the extent that I can, I try to take the legalese and put it in plain language. And people tell me, even when I think it's plain language, that I don't get there sometimes. But I refer to the foreclosure machine all the time. And that's because, based on all the cases I've studied, based on the attorneys I know in different states who are practicing, whoever shows up at your door demanding a payment under threat of foreclosure, they're all cut from the same cloth. They have been schooled the same way. They use the same type of practices and tactics in the foreclosure process. There are differences, of course, whether a state is a non-judicial type of approach they use to take a person's home from them. There's very little difference anywhere nationwide. And so I've referred to this body of foreclosure shops as the foreclosure machine. Makes no difference to me if it's if the person at the door says I'm with Wells Fargo, U.S. Bank, Deutsche. To me, they're all exactly the same, and I've yet to see evidence to the contrary. But it's not a term that you'll find in a law book, per se. The foreclosure machine has bigger names than we do. It has more money. It has more legal resources. So it's understandable that people will be intimidated and will be concerned that they have any chance at all of a fair hearing, any chance of really having their rights determined properly. But the fact is that the foreclosure machine, the pass, if you will, the foreclosure machine makes mistakes. They make mistakes in what they do in the court process. And so often, they are burdened by mistakes that were made when the loans were originally created, many, many years ago. And they can't fix those. The problem with the foreclosure machine has is that so often, it cannot establish the legal rights to demand payment. It cannot establish legal. They play games. They try to hide it, keep it below the surface. But that happens frequently. The South Essex County in Massachusetts did an audit of the foreclosures in that one county for the year of 2010, and they only looked at foreclosures by J.P. Morgan Chase, Bank of America, and Wells Fargo. On just those foreclosures and those names, the county found that 75% of those foreclosures were illegal. San Francisco County, which is where San Francisco is located, did an audit. They looked at 3 years of foreclosures in that county, 2009, 2010, 2011. They came up with 84% of their foreclosures were illegal. The U.S. Office of the Comptroller of the Currency issued a report in April of this year, the results of an audit they had conducted, and they looked at just 2 years, 2009, 2010, and they looked at the foreclosures that were in progress or that actually closed in those 2 years. The OCC's report said that they found 4.2 million illegalities in the foreclosures. Well, in this country, we've only been averaging about 2 million foreclosures a year. So that's effectively saying that they found something wrong with every foreclosure they looked at. Now, I mean, these numbers are sort of interesting, but the reality is that as a result of these studies, nobody was given their house back. That's not what the government was about. I mean, they did studies, but it hasn't resulted in homes being given back. The settlement agreement between the federal government and the state attorney general's offices didn't actually delve deep enough into the facts to identify the people who had had their homes taken improperly and make some compensation for them. That wasn't what the settlements were for. They were primarily, at least in my opinion, I think they were primarily to get rid of a stigma that was growing, a bad blight on the reputation of these huge U.S. financial institutions. Unfortunately, people are pretty much on their own. If a person's got a foreclosure notice right now, they need help now, and that's going to be the court. Political solutions, legislative changes aren't going to help the person that is facing foreclosure today. And that's what my materials are about, trying to provide information to help people, both attorneys and their clients alike. The debt collection process is misunderstood. The foreclosure is nothing but debt collection. And the fact that they throw out words like mortgages and promissory notes and securitization, the bottom line is that's all a foreclosure is. It's somebody that says, I'm owed some money, I've got collateral, and I want to foreclose. I want to sell the collateral to get my money that I'm owed. It's got a few more words than that, but that's the essence of what a foreclosure is. The nature of foreclosure is to make whole the person that's owed the money. What you'll see as you do more studies is that the machine that shows up, that demands payments, that threatens to take the houses, they rarely, when they are put to a test, they rarely can prove that they have the right to make a demand for payment. They have difficulty proving they have the right to foreclose. In my works, I don't spend a lot of time talking about the mortgage. And that's because the mortgage, especially in New Mexico, the mortgage is incidental. It is secondary to the note. The mortgage is collateral for a performance under this note. The person that controls the note, that is owed money under the note, they're the ones that control the collateral, the mortgage. In fact, there are court decisions in New Mexico that basically say that whoever controls that note has a right to the collateral whether their name is on a mortgage or not. I don't spend that much time with mortgage. I look at mortgages and give suggestions on how to challenge the assignments of mortgages, but quite often that leads to information that can help show that the company demanding the payments and threatening foreclosure doesn't have proof. But my primary focus is the note itself, the promise to pay. A foreclosure is never legal unless there's a default under the note. Now I'm not talking about a default like Mukhtar was talking about where somebody doesn't show up, they don't respond to a lawsuit. I'm talking about there has to be a default under the note. The banks, Wall Street, our federal government for the most part, will talk as if anytime a payment is missed, there's a default. Well, that's not the law. That isn't the way it works. Even if your note says that a condition of default or a default happens if you don't make your payments, that very same document gives the authority to the person in control of the note to decide if there's a default. Gives that person the sole authority to decide if there's an acceleration of the debt. Gives that person the authority to decide if there's going to be a triggering of the power of sale under a mortgage that lets the foreclosure start. So many people that are sued, if they answer a lawsuit, quite often they'll say, well, I'm in default. I didn't make my payments. They say that because they're ignorant. They don't know what the law is. If they have not been contacted by the person that's in charge of the note and they have received a declaration of default, they're not in default. It hasn't happened. That is, that's the law that is a composite reading, if you will, of the loan documents themselves, the note, the mortgage, and then the body of law that controls the issues about rights and obligations under the note. And that's the Uniform Commercial Code. So I spent a lot of time. When I was in law school, I never took a course about the UCC. I never knew an attorney that had taken a course about the UCC, although I assumed that one of the professors who taught UCC probably had. But in real estate foreclosures before this, before the 2000s started, people did not talk about the UCC in foreclosures. It wasn't until the securitization took place and these notes started being dealt with as what created the importance of the UCC in the foreclosure world. The approach in a lawsuit against the company that says, oh goodness, you owe me money, and if you don't pay me, I'm going to take your house. And I'm probably going to get a deficiency against you in the state of New Mexico. When that company shows up, the purpose of going to court against it is to make it prove what it says, to put it to a test under the law, and to get past all of the rhetoric, get past the hot talk, get past the smoke and mirrors, and make them show. That's where the UCC comes in. The UCC is a body of law that defines rights and obligations under a negotiable instrument. And I'm talking about Article 3. The UCC has all kinds of stuff in it. But Article 3 is about negotiable instruments. Negotiable instruments are, the basic essence of a negotiable instrument is it's got to have an amount that's due that can be understood by reading the document, when the payment is due, and it has to be transferable. Those are basically the three things. If you read the sections in the UCC about negotiable instrument and you stayed awake, you'd find that there are all kinds of words in there and sentences and all kinds of stuff that seems confusing. The essence of the litigation about whether something is or is not a negotiable instrument, typically out that's fixed and stated. Is there a payment schedule that we can understand? And is there any restriction on transferability? Residential notes don't have transferability restrictions. So as soon as the borrower is at a mortgage closure and they hand their notes and their documents to the lender, that lender can sell the paper, it can sell it, trade it, give it away, burn it up, and the borrower has no right to know what's happened. The loans do not give the borrower any right to know whether they get letters in the mail saying you owe some money or here's a new service or that kind of thing happens. Because this is a negotiable instrument, the residential loan is, that note puts the borrower at risk that somebody's going to show up with a copy of it or with the original, and they're going to knock on the door and say, oh, by the way, I've got this piece of paper that you signed years ago, and you owe me some money. And if you don't give it to me, I'm going to take your house. Well, the UCC, they need to be protected against somebody stealing the note, somebody, 4 or 5 people all coming up with copies and all making demands on the same thing. The UCC gives the borrower the right to demand. Whoever is showing up saying, I want your money or your house, the UCC says you've got the right to demand proof. What proof do they have that they have the right to enforce that note? The UCC says if they don't provide the proof, there is no. You also have a responsibility. If you pay your money to the wrong person, you get no credit on the account of who you actually owe the money to. I mean, this negotiable instrument is not. It's complicated when these valuable pieces of paper can float around anywhere. But the UCC is the protection. The UCC is the law that says when you go to court, you can demand that the person making claims against you prove it with facts. And what I routinely do somewhat follow the same pattern. My chapter 9 says, don't accept the machine's word. Don't take their word on anything is a good rule of thumb. They may be nice people, but you don't want to take their word. Chapter 10 says, gather and use facts to beat the machine. That's because the UCC creates fact-intensive tests. And the way you beat the machine, unless they just admit it, prove the facts, show the facts that they say support their claim against you. And what you'll quite often, when they're put under this pressure, what the machine does is that it may have something up here for 1 year, and then there's nothing at all for a year, and then something comes up down here. And all of these gaps, basically, if they can't be filled in and explained with fact, not with just hot words and talk, they can't be proven with fact as to what was going on with the note itself, the machine, we're fortunate because this is a judicial foreclosure state. The people wanting to foreclose have to start the lawsuit. That puts them under a burden of having to prove standing, a burden of having to prove whatever their claims are. Now that burden can shift. If they put on a little bit, a little bit of a show, that could possibly shift the burden to the defendant. But because you have a right to use discovery in a lawsuit to get facts, it's the facts. The facts, they will not have facts to show why they've got an assignment that says they got their name on a mortgage. They may have a pretty piece of paper that it looks formal, it's got all kinds of fancy words on it, it'll have a stamp like it was recorded in the state county, in the county's public record someplace. Fine, it's just a piece of paper until the facts about who created it, when they created it, why they created it, under what terms it was created. That piece of paper, facts, is the way you beat these people. The note can be transferred. It can be, if I'm the boss of the note, and I use that term all the time just because something I coined when I was writing the book, but the UCC doesn't have a single label that applies to who has the right to always enforce the note. It's almost like reading the Internal Revenue Code, which most of you may not have done, but I did that too much. But anyway, the law references 2 sections over here, 3 sections here, and you go round and round. But the long and short of it is that the boss of the note is the concept. Only one person at any one time in the history of your note that has the right. And the right to be the boss and to control what happens with that instrument can change. If there's a sale, it can transfer to the next person. That person can sell it. Maybe it transfers, maybe it doesn't. It all depends on the facts. And the foreclosure machine has terrible trouble. Just the assignment document. They'll show up with a copy of the note, not even the original, copy, and it'll show, they'll say, well, it's got an endorsement on it, so I got it because it's got a blank endorsement or a special endorsement, those special terms. The bottom line is, until all the proof comes out about what they actually have, where they got it, how they got it, who they got it from, whether they got it from somebody that was the boss, bottom line is they haven't proven anything. And that's what comes out in courts all across the country, the foreclosure machine. So the borrower has more options than what they're led to believe by the banks and the foreclosure machines. It's not as simple as do what we say or else. A good lawsuit can enhance the chances of a good settlement, a meaningful modification that's actually affordable, instead of just something that puts the person under more pressure with a short fuse. It's just that simple. So that's the essence of what I do. And I do think our courts can help, and I do think that that's probably the only short-term solution, is to go to court and help your judge and pick on these guys. I think it's good. And my wife tells me that saying picking on the foreclosure machine is not really that bad, because usually we think about picking on somebody that's smaller than you. So yes?
Robert, did you have you in your
In New Mexico? New Mexico doesn't have many published decisions in the traditional sense, the appellate decisions. But I had a judgment that was vacated just a few months ago that I was helping an attorney with here. I know of several cases where that's happened. And I've seen quite a few motions that were denied. The foreclosure machine had put forward motions that have been denied where the judges are starting to get it. So I'm inclined to think that there are some wins that are taking place.
Can you write down your questions and turn them in?
Oh, okay. I think that's right. Sorry. I think there's going to be a formal question and answer section. So write down your question and we'll try to take care of it.